At its core, the rule of law dictates that everyone, from the average citizen to the state itself, is strictly bound by clear, accessible, and prospectively applied laws. It exists to prevent the arbitrary exercise of government power. Traditional theorists like A.V. Dicey viewed this primarily as a procedural requirement. Modern interpretations, like Lord Bingham's, argue it must also protect fundamental human rights. Look at the apartheid era in South Africa. The system was legally valid and followed correct procedures under its constitution, but it resulted in gross oppression. Substantively, it lacked legitimacy. In the UK Constitution, this principle collides directly with parliamentary sovereignty. Because Parliament is supreme, it can legally enact legislation that contradicts fundamental rights. The Safety of Rwanda Act, which directed courts to treat Rwanda as a safe country, regardless of evidence to the contrary, highlights this tension. When courts face this conflict, they apply the principle of legality, established in the Sims case. Judges will ask a specific question. Did Parliament use express, clear, and specific language to override those fundamental rights? If the language is vague, the courts will interpret the law to protect human rights. If Parliament's wording is explicit, the rule of law ultimately yields to the supreme will of the legislature. To prevent unchecked power, constitutional design normally relies on the separation of powers. This divides the state into three distinct branches: the executive, which administers the law, the legislature, which makes the law, and the judiciary, which resolves disputes. The UK does not have a strict formal separation. The Prime Minister and the Cabinet, who form the executive, sit directly within the legislature. This structural overlap usually gives the government an inbuilt legislative majority, a setup Lord Hailsham referred to as an elective dictatorship. To measure the functional separation in this fused system, we look at statutory personnel limits. The House of Commons Disqualification Act caps the number of government ministers who can sit as members of Parliament at 95, preventing the executive from completely absorbing the legislative chamber. Unlike the rigid boundaries found in the United States, the UK system is highly integrated. It relies on a network of internal checks, balances, and constitutional conventions to hold the government accountable and prevent tyranny. The courts have the authority to check the executive through judicial review. They determine both the legality and the extent of government powers, including ancient royal prerogatives. We saw this in the second Miller case, where the Supreme Court ruled the Prime Minister's advice to prorogue Parliament was unlawful. But there is a hard limit to this oversight. Certain prerogative powers are classified as non-justiciable. These involve matters of high politics, such as the signing of international treaties, the deployment of armed forces, and the granting of honors. These areas are completely off-limits to court intervention. To decide where a case falls, courts use the justiciability test from the CCSU case. They evaluate the nature of the power being exercised. If it concerns national security or high foreign policy, it is non-justiciable.
If it is an administrative function affecting individual rights, the courts can review it. Let's test this logic. Imagine the UK government signs an economic treaty with South Africa that severely damages British businesses. Can those businesses ask the courts to review the signing of that treaty? The answer is no. This is a common exam trap. While the courts possess the power to determine if a prerogative power actually exists, they will not review the exercise of a high politics power like treaty making. The courts willingly draw this boundary around their own authority. They recognize that matters of foreign policy are better left to the elected government, preserving their independence from highly political disputes. Prior to 2005, the UK's separation of powers was heavily blurred at the judicial level. The highest judges in the country, the law lords, physically sat and voted inside the legislative chambers of Parliament. This chart illustrates the current structure of central government. The Constitutional Reform Act of 2005 resolved that historical overlap by establishing a fully independent Supreme Court and a merit-based Judicial Appointments Commission. The Act also reformed the role of the Lord Chancellor. While the Lord Chancellor remains a political appointee within the executive branch, their former roles as head of the judiciary and Speaker of the House of Lords were stripped away. We verify the independence of modern judges through three structural pillars. They have secure tenure and cannot be easily dismissed. Their salaries are paid directly from the consolidated fund to prevent political interference, and they maintain broad immunity from civil action for their rulings.
By physically and legally extracting the highest court from the legislative process, the Constitutional Reform Act formalized a distinct judicial branch within the UK Constitution. This brings us to the most severe point of constitutional friction. What exactly do the courts do if a primary act of Parliament blatantly violates human rights? The rule is absolute. The judiciary must apply primary acts of Parliament. Because the UK lacks a codified constitution acting as a higher law, the courts do not have the power to strike down primary legislation. The Human Rights Act 1998 provides a specific mechanism for this conflict. It gives courts the ability to issue a declaration of incompatibility if a statute breaches the European Convention on Human Rights. The workflow requires a two-step test. First, under Section 3, the court must try to interpret the Act's language to comply with human rights. If that is impossible because the legislation is explicit, the court moves to Section 4 and issues the declaration. But pay close attention to the result. A declaration of incompatibility is only a mechanism of political pressure. The offending act remains fully valid, legal, and enforceable until Parliament itself chooses to amend or repeal it. The UK operates on a delicate balance. It maintains a functional separation of powers and a deep commitment to the rule of law. Yet, when push comes to shove, parliamentary sovereignty always has the final word.